Restructuring a family is painful and confusing to parents as well as kids. A common question concerned visitations for children under the age of 3. Are they the same or are they different? Live at 5's family attorney Sonia Kaufman joins us now with more. And we've got lots of questions today. So 3 years old and under, are the visitation rights different when it comes to custody battles?
They are. We're often asked when overnight visits start with a very young child. And the standard order that so many people are familiar with really doesn't start until the child is age 3, when it's presumed to be in the best interest. So the judges decide what's most appropriate for the young children, and recently the legislature has codified the factors that the court needs to consider in making that determination. One of the big factors is how has parenting time been divided before the people got to court. For example, if usually it's a father of a very young child is trying to get overnight visits, the court will look at whether he's had those before coming to court already. Oftentimes the visitation is incremental, meaning that it's gradually increased with the non-custodial parent getting more time. So there are a lot of factors, case specific, but you need to talk to an attorney about those issues.
Okay, on to our KFDM News Facebook page. Like I said, we've got lots of questions. Can a non-custodial parent voluntarily relinquish their rights without being in agreement to do so with a custodial parent? If so, does this relieve them from having to support their child?
And believe it or not, that's a common question too. Judges are very reluctant to terminate a parent's rights if the reason for doing so is to terminate the support obligation. So generally the answer is going to be no, the court's not going to do that. The most common situation is if, say, a father terminates rights and a stepfather adopts. And then in that case, the biological father's obligation to support would be terminated. But strictly giving up rights for the purpose of avoiding child support, no.
Okay. Another question, I'm trying to get custody back of my son, can't afford an attorney, but CPS hasn't done their job either as far as my child's situation. Living conditions are not good. Mental abuse is no good either. Can you tell me where to go from here?
Trying to get custody back, that's going to involve either CPS making the placement of the child or the judge deciding what's in the best interest. Now, if this person can't afford an attorney, they might check with Lone Star Legal Aid about getting a pro bono attorney appointed for them. It, however, would be very difficult to represent herself without an attorney.
Okay, another question. If a child doesn't have the man's last name, never had a DNA test to prove it, that it was his, never gets to see the child, and never signed the birth certificate, should the man have to pay child support?
Well, if he has been ordered to pay child support, it's a legal obligation. But if there's some doubt about paternity, I think we talked about this a couple of segments ago, there's a new law in place now that says you can go and have genetic testing no matter the age of the child. If he's not the father, then that support obligation would be terminated.
All right. And unfortunately, we are out of time, and we've got lots of questions, but we'll get to those next time. Sonia, thanks.
Thanks for having me.
And if you'd like to have a question answered about family law, you can let attorney Sonia Kaufman answer your questions. Fax us those questions, 892-7305. Email us at laf@kfdm.com, or you can post them on our KFDM News Facebook page.